Good afternoon. My name is Tom Capasso. I'm Deputy Court Administrator for the Juvenile Court. And in my prior position, I was at the Office of the Commissioner of Probation, and I was Director of Records, which ultimately oversaw the sealing and now, with this new legislation, the expungement of criminal records in Massachusetts. This video will be about sealing and expungement and is also part of a series of presentations produced by Veterans Legal Services in collaboration with Massachusetts Continuing Legal Education. These videos are to assist veterans and service providers with identifying legal issues and determining when to contact an attorney. They are meant to be informative, but are a general resource. Veterans who need legal assistance with a specific situation should contact Veterans Legal Services at 857-317-4474 to see if they qualify for legal representation. So let's get started. I think it's important we should talk about sealing first. There were some substantive changes to the sealing statute most recently with the most recent criminal justice reform bill that was passed, but they're not that significant, so I think we can cover that pretty quickly. So hopefully people are aware, in order to seal your record in the Commonwealth, there are two mechanisms for sealing. One is through direct petition to the Office of the Commissioner of Probation. You can obtain a copy of that petition by contacting the Office of the Commissioner of Probation. And then there's another mechanism for sealing whereby you petition directly to the court where the criminal offenses took place. And there are separate reasons for which you would petition probation or why you would petition the court. Probation by statute is required, or is the entity that's required to allow for the sealing of convictions. So if you have convictions and you're seeking to seal those, a judge does not have the authority to seal those. You must file what's called a 100A or B petition with the Office of the Commissioner of Probation. If you have non-convictions, those, for example, not guilty, a null pros, a case that didn't result in a conviction, a case that was outright dismissed, a case that was initially continued without a finding, but it was ultimately dismissed without any violation or anything of that nature, you can go directly to a court and ask a judge to seal those. So one of the common questions I get is, which way is the right way to go? And there really is no right way. The reason I mention that is because the Office of the Commissioner of Probation will also seal non-convictions for individuals, but they follow the same time frames as they would for convictions. So what does that mean in practical terms? So what that means is if I have two individuals were involved in a particular unfortunate instance that criminal charges arose out of, and they were both charged with the same offense, let's say it's an assault and battery. And let's just say one individual wound up being convicted, but the other individual did not. The individual with the conviction has to wait the statutory time period prescribed in order to seal their record, and they must do so by petition to the Office of the Commissioner of Probation. The time frame prescribed for a misdemeanor is now 3 years. The legislation recently changed that to 3 years. It used to be 5 years. That's the first big change in the legislation. For felonies, the new time frame is 7 years. It used to be 10 years, and that's another big change to the legislation. So the individual with the conviction, let's say it's myself, must wait. So I sit and wait for the time period to pass. The individual with the non-conviction, technically the statute says they can file what's called a 100C petition, Chapter 276, Section 100C, and they can file that petition in the court where the matters took place. However, the judge and they can file that immediately upon disposition. They don't have to wait any time frame. But a judge has authority there to determine if that's in the best interests of justice, and they can deny that petition. Now, there's nothing to stop that individual from going back to the court, say a year later, maybe 6 months later, and repetitioning. But at the same time, there's nothing to stop the judge from, again, denying the petition. So what the Office of the Commissioner of Probation has determined is that if that individual with the non-conviction has waited the requisite statutory time frame, in this case, let's say it's 3 years because of a misdemeanor, and still they weren't able to seal their petition because they've been denied by a judge, they should still be given the same equitable remedy as the individual with the conviction. It only makes logical sense. So that was what would happen. If the individual was continually denied, they could still file the 100A petition, and that non-conviction would be sealed exactly at the same time as the individual who picked up the conviction. So that's just a basic example I use when I discuss this with individuals. Again, important to note, as it relates to sealing, the time frames is the biggest change in the most recent legislation that was passed. Historically, people had to wait 5 years for misdemeanors to become seal eligible and 10 years for it to be felonies. Those timeframes have been changed to 3 and 7 years, respectively. People often ask, when do you start the calculation? When does my time start ticking? When does the clock turn on? And the easiest way to think of it is, if it's based on a conviction, its disposition date, unless you served incarceration period, whatever that may be, then the time does not start until the day you were released from the incarceration period. That's the easiest way to remember it. Okay? There are some one other big change to the only other really big change to the sealing statute with the most recent legislation is that there are a number of charges that the convictions of those charges are ineligible for sealing. It's built into the statute. They may not necessarily be charges you would suspect, but they're listed in the statute, 276-100A, and they specifically are laid out there. And these are only the convictions for these offenses, mind you. Non-convictions for these offenses are certainly sealable. But they are typically, the Chapter 140, a lot of the firearms violations, and there's also a lot of intimidation of a witness is one of those charges. Now, historically, resisting arrest was also one of the charges, the conviction of which was not eligible for sealing. That has been changed. So resisting arrest convictions are now sealable pursuant to the new legislation. Those are the three biggest changes as regards sealing. The time frames were rolled back for misdemeanors from 5 years to 3, for felonies from 10 years to 7, and the resisting arrest prohibition for sealing a conviction on resisting arrest has been lifted. If you have additional questions or want to obtain the necessary forms regarding sealing of records, I would suggest you contact the Office of the Commissioner of Probation, and I believe we'll make these forms available as well as part of this presentation. Moving on to expungement, because that is a far bigger topic, I would suggest. And again, this is the first time I would suggest in Massachusetts any legislation has been codified with relation to expungement. So let's talk a little bit quickly about what's the difference. What is the difference? What's sealing do vis-a-vis what's expungement do? Sealing is more of a shielding of your record from view. When you seal your record, you're really only sealing your Massachusetts court history as it pertains to that record, and you're only shielding it from view in certain instances. So what do I mean by that? Law enforcement will always have access to anything that's sealed. That's built into the statute, 276-100D. Section 100D says law enforcement is to have immediate access to this information, and they do, and they would obtain it in the manner they would anything else, anyone else's record. They would send a query through the system. But sealing is also really helpful in instances where people are seeking to gain employment, and those employers or housing entities are doing what's called query checks. If your record is sealed, then a query check is conducted upon you. It's as if that charge does not exist. They would not be provided proof, or they would not be provided with that information. But it still exists in perpetuity. It's there, and in certain instances, as I mentioned, law enforcement is a good example of this. It is referenced. Expungement is another matter. Expungement is total destruction of the record. So if someone is able to get something expunged, it no longer exists. Law enforcement wouldn't be able to see it. It would be as if it was ultimately destroyed. And that's significant. But because of that, the legislature was cautious, I would suggest, in their first crack at expungement, and really limited who's eligible for expungement. There are two specific versions of expungement, and we'll talk about those now. I'll talk about the latter one first because it's much more it's more open-ended, but I would suggest it's much easier to understand. So Chapter 276, Section 100K, talks specifically about expungement that's available via a court. You're able to file a petition in the court where those charges took place, and you're able to file those specific to certain categories. You would have to prove to the court that those charges existed based upon the false use of your identification unauthorized use of your identity, theft of your identity. The offense described is no longer a crime. Possession of marijuana, let's suggest, would be one of those. Errors by law enforcement, errors by a civilian or expert witness, errors by a court employee, or some fraud perpetrated upon the court. Those are really narrow instances. The form for expungement that pertains to this is a petition for expungement, and the statute is listed specifically 276-100K. That will also be available as part of this presentation, and it lays this information out. So that is, I would suggest, open to anyone, meaning any individual can file such a petition, but they're going to have to prove that those charges they're seeking to expunge were created as a result of all of those categories that I just mentioned. One of at least those categories I just mentioned. Okay? Some examples of that perhaps could be, again, case of mistaken identity. Let's say you have a sibling, unfortunately, or a friend who's used your information, and unfortunately that got all the way to the point of a charge being created. This, I would suggest, is the remedy for you. You're going to have to prove to a judge that this is the case. But if you're able to do so, then those charges can be expunged. And the form details specifically the process for that. There may be a hearing before a judge. Again, this is still very novel law. I would suggest that the legislation just became effective as it relates to sealing and the sealing changes I mentioned and expungement on October 15th of 2018. So we're really only about a month and a half in. I'm not exactly necessarily even sure that I've heard of a 100K expungement that's been decided in the courts yet, but I'm sure they'll be coming. To the extent that you feel that you're eligible, I would encourage you, again, to perhaps speak with Veterans Legal Services or some other legal services organization, and the form will be available here for your review. The second part of expungement is more open-ended in the sense that you don't have to argue that the case was based upon any of the conditions I just mentioned. It's more of a time-based petition for expungement, which means after a certain period of time, people are eligible to file and have their charge or their offense, the statute says, expunged, but they have to meet a number of specific characteristics or criteria that is laid out in the legislation. And I would suggest that it is the nature of those criteria that limit the pool of people who will really be eligible. There's another petition to expunge that will be attached to, or available, I should say, after this presentation as well. And the sections of law that pertain here are Chapter 276, Sections 100F, G, and H. Okay? And the form looks very different, and again, it's different because it's handled in a different way. These petitions go to the Office of the Commissioner of Probation. We talked about a little bit earlier. That's where a lot of some of the sealing petitions go. And it is up to the Office of the Commissioner of Probation to determine whether the individual who's filed the petition is eligible at all. If it's determined they're eligible, then that gets sent to the District Attorney's Office. They then are given an opportunity to respond if they choose. They can object. They can not respond. They can not object. Whatever that case is, they send their response to the Office of the Commissioner of Probation, and then it's sort of packaged almost as if the Office of the Commissioner of Probation were almost like a clerk's office, forwarded to the court that's responsible for making the determination. It would be, again, the court where these matters took place, and then a judge may or may not hold a hearing depending upon the circumstances, whether or not the district attorney objected or not, and make a determination. But I think the most important and crucial factor here is to determine what are the criteria, okay? The petition to expunge lays out the criteria in as simplistic language as possible. The trial court recently took on a really big undertaking to indicate that any new forms, and this qualifies as a new form that are created, need to be created as simplistically as possible, and I think this form accomplishes that. So the very first criteria is the individual had to be under the age of 21 when the offense was committed. So right away, that leaves a large portion, I would suggest, of the population ineligible for expungement. Again, I would just say keep in mind that this is the legislature's first foray into the expungement process, As we move forward, there could be additional legislation that is passed that groups other individuals into the eligibility. But right now, as we currently stand, when it comes to time-based expungement, the only individuals who will qualify are individuals whose whose offense was committed before they're the age of 21, okay? So if that criteria is met, the very next criteria is they can have no additional offenses, okay? This is really limited to individuals at this point in time who were of a specific age, under the age of 21 when they committed the offense, and they have no additional offenses. And that's not just with respect to Massachusetts crimes, but it could hold true. It holds true for other jurisdictions as well. So the Office of the Commissioner of Probation, when doing their analysis, will run some checks into other jurisdictions. And if it turns out, yes, I had when I was 20 years old, I had an assault and battery in Massachusetts, but you also have, say, another assault and battery in another jurisdiction, you would also be excluded from filing the petition further with the court. There's also a number of other criteria we'll touch on briefly. You cannot currently be the subject of an active criminal investigation by any criminal justice agency. You can't have any active warrants here or in any other jurisdiction. Can't be under investigation, as is mentioned. Again, much like sealing, there are time frames that are prescribed here as well, and they are the same. If the offense is a misdemeanor, it has to have at least been 3 years ago. If the offense is a felony, you had to have waited at least 7 years to file the petition. One slight difference, a nuanced difference here, is, again, let's talk about when the clock starts ticking. With sealing, we talked about the clock ticks at disposition or upon release from incarceration. For expungement, the language is specific that it starts ticking at the end of all custody. So what does that mean? Let's say you served a probationary term. For expungement purposes, your clock doesn't start ticking until you've finished your probationary term. For sealing purposes, they would give the benefit and say it starts ticking right when you put on probation at disposition day. And the rationale behind that could be, again, significantly different interests are at stake here. Sealing, your record still exists. It's just sort of shielded from people in certain instances, whereas expungement, we're totally wiping it away. Okay? The next group of criteria that I'll talk about are something that I think will be the subject of much discussion, possibly even litigation as we move forward, because they're somewhat open-ended, but they are listed in the statute, and they're on the form as well, so I'll discuss them now. The next one is that the offense did not result in death or serious bodily injury, or nor was committed with the intent to commit or to cause death or serious bodily injury. If death or serious bodily injury was the result of the offense, that would be very easy to determine by the nature of the charge and through some investigation by, obviously, the Office of the Commissioner of Probation. The intent piece is much more difficult to determine. So I think as we currently sit here today, it's again, to use the same word, it's the intent of the Office of the Commissioner of Probation to indicate that so long as death or serious bodily injury did not result, they're not going to read into the fact that the individual had the intent to do so. Now, that doesn't mean when the matter gets before a judge, and more additional facts come out, they may not feel differently. But at the initial stage, which is what happens when you file the petition, and they're triaging, sort of, if you will, whether or not to pass this on to the court, that is one of the determinations that will be made, and that's how it will be reviewed. The offense was not committed while armed with or carrying a dangerous weapon. Again, that's really easy to determine if the person was charged, say, with assault and battery with a dangerous weapon. It's not so easy to determine in other instances where, say, there was a charge of larceny, but perhaps the individual was armed with a dangerous weapon when the act was committed. Again, the Office of the Commissioner of Probation, when doing their review, will look at the evidence they have to the extent that they have it. If they have police reports, if they have docket information, they will review that. And if they don't, the intent is not to, I would suggest the intent of probation is not to read into anything that isn't clearly there. So they will then pass that along again and the judge would make the ultimate determination. So if an individual were testifying and the judge were asking that question, and the individual admitted to carrying, say, a dangerous weapon that was unknown to probation at the time, well, that's something that the judge will then determine. But at the initial time of filing, there's only so much information available to make these types of determinations. The offense was not committed against an elderly or disabled person. Again, some of this information may be available, some will not. The offense is not a sex offense involving a child, or a sexually violent offense. Again, that's all by statute, and that's something that's very easily discernible. The offense is not operating under the influence of liquor or drugs. That's pretty significant, I would suggest, because as someone who's overseen the sealing of records for the better part of 4 years, a large number of individuals filed to have operating under the influence charges sealed. Unfortunately, in this version of legislation, there is no ability to file a petition to expunge any operating under charges. The offense cannot be a firearms violation or a violation for illegal sale of a firearm. It cannot be a violation of any restraining or harassment prevention orders. This is, again, something that's also quite common, is an individual that I've seen on the sealing end. An individual will have a restraining order and then, for whatever reason, be charged with violating that order. That violation itself is not eligible for expungement. Eligible for sealing, but not expungement. The offense is not an assault or assault and battery on a household member. Okay, so anything domestic, so to speak, would not be eligible. And lastly, the offense is not a felony violation of General Laws, Chapter 265. Now, Chapter 265 is a very lengthy provision of the General Laws. I would suggest, if you want to know exactly what felonies are listed there, you go and look at Chapter 265. It was far too long to include, or speak to, obviously, legal counsel. It was far too long to include on the form. But those are the criteria that determine whether or not someone is or is not eligible to have their record expunged based upon time-based expungement. Again, this is a new area of the law. I'm not aware as of yet of any 276-100 F, G, or H petitions that have reached the argument phase yet. There have been some that have been filed that I'm aware of. They're working their way through the initial process. There are time frames set out that I didn't discuss at the outset as to how long these petitions take, which they're laid out in the form as well. I won't delve into those too deeply, because I don't think it's significant for this type of a discussion. But as we move forward, these types of issues may get litigated, and the process may change. But as we sit here today, I'm not aware of anyone who's been granted expungement on either level. I would just remind everyone that all the criteria I just mentioned are specific to the time-based expungement. So what I mean by that is, say if you were a victim of identity fraud and you were 28 at the time, none of this applies to you. You file the 100K petition that I discussed earlier, and that goes before a judge, and they would then determine whether or not you meet, whether or not the balancing determines that it's in best interest to expunge that case. So those are the basics for sealing and expungement as enumerated by the most recent criminal justice reform. I would suggest, if you have questions, again, seek legal counsel, talk to Veterans Legal Counsel. You're certainly free to contact the Office of the Commissioner of Probation. They have a legal department as well as a sealing unit, an expungement unit that can help with some of these questions. And hopefully, as time goes on, we'll do some updating to this training as new law becomes more, common, so to speak.